Okay, good morning, everyone, and welcome to the District of Columbia Court of Appeals. I apologize that we're a few minutes behind this morning. Thank you for your patience. I'm joined this morning by Judge Beckwith to my right and Judge McLeese to my left, and I am Chief Judge Blackburn Rigsby. And we have just one case for argument today, Michael D. Flowers versus District of Columbia. Counsel, are you ready to proceed?
Morning, and may it please the court. Adrian Madsen on behalf of Michael Flowers. I'd like to reserve 3 minutes for rebuttal.
Great, thank you.
I'd like to begin with a discussion of the minimum showing required to obtain a continuance for a missing witness. As discussed in the briefing, that standard, certainly for continuances based on missing witnesses, is governed by the DC Circuit's decision in Newfield versus United States, which remains binding under this, on this court under MAP versus Ryan. That test, which this court has reaffirmed in O'Connor in 1979, and which would in any event remain good law under MAP, requires at minimum a showing of 5 elements. Those are, if the continuance is sought for the purpose of securing the attendance of witnesses, it must be shown who they are, what their testimony will be, that it will be relevant and under the issues in the case and competent, that the witnesses can probably be obtained if the continuance is granted, and that due diligence has been used to obtain the witness's attendance for the trial as set.
Mr. Marsden, oh, sorry.
Go ahead, Chief. Yeah.
Even if we were to agree with you that one or more of the elements to that test were not satisfied here, you still have to get over the prejudice problem to determine whether or not this was harmless or harmful error. And it seems under our recent precedent in Carper, and we had another case last year, which I think Judge McLeese may have written both of those, that you have a pretty high hurdle on the prejudice count here. The defendant was not detained pre-trial. This is the complaining witness. So I guess, do we need to focus so much on the factors here, even if we were to concede that perhaps all of them weren't met here? We still have to get over the bigger prejudice prong, don't we?
Sure, so I'm happy to address that, Your Honor. I think my reason for addressing in that order is because so there is another articulation of showings that is required, in my view, that is mistaken, that includes prejudice to the opposing party as one of the 5 or 6 quote unquote factors, which again, I believe are elements that a trial court discusses. And so in Cox, which is the decision Your Honor is referring to from last year, when this court was discussing those factors, or again, what it articulated as factors, it was acknowledged a conflict in the case law about whether these are elements and these are factors, and said, you know, because the parties here are discussing these as factors, we, the court, are going to do the same. That, in my view, is foreclosed by Newfield. That is, these are elements, not factors. And so when we're talking about the showing that's required in the trial court, leaving aside for a second the question of harm, prejudice to the opposing party is not part of the minimum 5 field.
But can I ask you, I know you'll get back around to harm, but when you say a showing, what do you mean that the government has to, you know, proffer, like in their request, their request for the continuance here, they, you know, if that met your requirements, you weren't satisfied by what they said there, but would that be enough? Or how much of this is about the judge having to then, you know, assess those factors, weigh them, decide, you know, kind of wrestle with the equities of the question? Or is it just enough for the government to show?
Well, no, I mean, I think ultimately the court has to be satisfied that the government has made the showing, has to make findings regarding these things. I mean, I think that's the way this court has applied it in O'Connor. That's the way the court has applied it in Kimes and subsequent cases. I'm sorry, I think Your Honor.
No. I continue. I'm just thinking and looking like I'm going to say something, but it's not true.
And so, but the point is here, the district did not even give the court a proffer on which the court could have made those findings. And so we don't necessarily have to grapple with, you know, the precise contours of the level of detail that is required, because it didn't offer them at all here. And so the court didn't have a factual basis to do that.
So is your argument that we can't get to prejudice prong if all of the factors haven't been met and that they haven't been met here?
Slightly different, Your Honor. That is that prejudice is not one of the 5 elements. When this court in Cox was discussing prejudice to the opposing party, so that is not a discussion that should have been happening under Newfield. That is, we have the 5 elements, one of which is not prejudice to the opposing party. You know, this court sort of specifically flagged in Newfield, in Cox, that, you know, it wasn't addressing this conflict in the case law. What I am saying is that under the correct standard governing, there would have been no discussion of prejudice to the opposing party.
As one of the factors the trial court was required to consider in determining whether or not to grant the continuance request.
Yes, sir.
But let's assume, again, wrapping back around to Chief Judge Blackmur's question. Assume that we were to agree with you that for one of several reasons you raise, the trial court erred in granting the continuance request. Then the issue is, in what circumstances do we reverse and in what circumstances do we affirm? And there too, there's the concept of prejudice then arises again potentially there in determining whether reversal is warranted. And so what's your argument about why, assuming that you're correct that the continuance shouldn't have been granted, you're entitled to reversal rather than affirmance on a no prejudice / harmless error analysis?
Sure. So I guess first, in terms of what I think the standard for reviewing harm there is, I believe that is for non-constitutional harm, where on Kadiakos, that the government bears the burden of showing that it is highly probable that the error did not contribute to the verdict. And so
Can I ask you, while you're saying that, can you, you addressed one of the 2 cases that Chief Judge referred to, the Carper case, but the Cox case, but I know you're familiar with the Carper case, as am I. And I noticed that your reply brief didn't really address the Carper decision, although the district's 28K letter had preceded your reply brief and referred to Carper. So I'm interested in your thoughts about how the position you're articulating just now squares with the approach we took in Carper.
Yes, sir. And so the reply brief was filed briefly before Carper, so that is why it wasn't addressed in the reply brief. That is Wednesday to Thursday. But but in terms of how I think that plays out here, so Carper relies on Cox for the proposition that that a witness testimony, the fact that a continuance resulted in the witness's testimony is not itself prejudice. Cox relies on a Fifth Circuit case, which I'm sure Your Honor may recall, in saying, but the Fifth Circuit case that this court relied on in Cox, which then Carper relies on, was discussing a 403 unfair prejudice. So even if we were leaving aside that one of the factors that or one of the showings that the court should not be before the court when deciding whether to grant a continuance based on a missing witness is prejudice to the opposing party, it's certainly not unfair prejudice. Now we might say, you know, well, colloquially, that is that anytime there is an error and there's some prejudice for that, maybe in that sense that it's unfair, but it's not unfair prejudice in the 403 sense. So my point is in saying that if Cox had been following Newfield, there would have been no discussion of a prejudice to the opposing party, let alone unfair prejudice.
I'm not quite sure I follow that. Are you saying that Newfield forecloses the idea that in order to prevail on appeal on the theory that a continuance is erroneously granted, you have to show prejudice? Because Newfield doesn't, I didn't understand Newfield to address that topic.
So Newfield addresses, I agree, the showing that is required in the trial court. Part of that showing is not prejudice or lack of prejudice to the opposing party. So
I'm
assuming for the sake of argument.
Perfectly willing to assume that as we did in both
Yeah.
Cox and Carper.
So assuming that we have that there, Carper, when discussing Cox, just not to use it again, but discussion of prejudice, refers to the trial court's consideration of prejudice. That is, when this court in Carper is discussing Cox, the discussion in Cox is about the trial court's consideration of prejudice, which
To simplify a little bit, I mean, it
Yeah.
gets a little difficult to, Carper's view of Cox's view of Newfield. You get, it gets pretty elaborate, but just focusing on Carper.
Sure.
Carper says there, essentially analyzes the issue in part as a harmless error issue. Says, that we're going to analyze this as on the question of whether the assumedly erroneous grant of the continuance warrants reversal. Carper said, that our decision in Carper said that Mr. Carper had tried to raise a non-harmlessness or a harm argument on appeal by saying, look, the continuance allowed the government to introduce the testimony of a witness who otherwise would not have testified. And then we said, basically, that Mr. Carper didn't cite any support for that idea as the kind of harm that would warrant reversal, and that we were not inclined to think that reversal was warranted. Why isn't that same mode of reasoning applicable here?
Sure. So the one, I think that is, again, because in reaching that conclusion in Carper, the court was relying on Cox.
No, well, in the paragraph that I'm referring to, I don't know if you have it in front of you, but there's a paragraph where we say who knows what the abstract relationship is among abuse of discretion, prejudice, and harmless error. We don't have to wade into all of that. We're going to look at it as a harmless error. This is paraphrasing now. We're going to look at it as a harmless error question, and here's our analysis of harmless error. And when we do the analysis of harm in the following paragraph, there's a CF to Cox. But it's analyzed as a harmlessness question, and the court concludes that the idea that had a continuance not been granted, the witness who ultimately testified would not have, is just not the kind of harm that's going to warrant reversal. That seems to me to be the mode of reasoning, and I'm just not quite sure why it isn't applicable equally here.
Sure. I guess throughout Carper, the court sort of repeatedly refers to prejudice, and I'm not trying to refer back to Cox, but when addressing this as a harmlessness error, the court sort of repeatedly refers to prejudice. And what I am saying that while that might be prejudice might be a sort of shorthand way of describing Katiakos, or the standard for non-constitutional harm, what the standard is, whether it is highly probable that the error did not.
I get that line of thinking, I guess, but that sounds like it might be more an argument that you think that Carper incorrectly applied a harmless error analysis.
Yes,
and if you think that may be a fair critique of Carper, but I'm not sure it's anything that this division could do anything about.
I guess sort of that is well, two things. One is, and I know it doesn't change the fact of where we are today. There will be a petition for rehearing, but my point in saying that Carper reaches this analysis based on Cox is that Cox, again, under a proper analysis, would not have been discussing prejudice in the way that it was. And
I guess that's where I get a little confused, because what Cox said was, I think, it's paraphrasing again, so feel free to correct me if my paraphrase runs off the rails, but
If your paraphrase of your opinion
yeah.
runs off the
but I could easily be misrecollecting for sure. So I thought what Cox said was, we're going to assume that it was error to grant a continuance. The analysis that applies for whether those errors are reversible or not is a little unclear from our cases. Some of them treat it as though there's a burden on the party who's raising that objection to show prejudice on appeal. Not, again, prejudice, as part of the correctness of the trial court's original ruling, but prejudice as a component to reversal on appeal. And then there are the harmless error cases, and we said in Cox, paraphrasing, that, we're not going to really, we don't have to decide that question either. So I'm not quite sure that discussion of the idea that one possible way of analyzing the entitlement of a party who's objecting to the granting of a continuance to get reversal on appeal is to look at whether that party can show prejudice of the relevant kind. I'm not quite sure why you think that's that's either like inconsistent with Newfield or any of our other cases. That seems different from whether prejudice is part of the multi-factor or multi-requirement test the trial court's applying and making its original decision about whether to grant continuance or not.
So to take your honor up on your honor's invitation of characterization, I think that is going slightly off the rails from what was decided in Cox. And so so in Cox, and this is at 369, the court stated, we have identified a number of factors to consider when reviewing a trial court's ruling, granting or denying a continuance so the party can obtain additional evidence, pointing there to Gilliam, after saying that it wasn't going to decide which of those were true. The court then goes through the factors that the parties in that case agreed on, which again, it's a bit as error, but and in that context, that is discussion of the factors, and this is at 370, turning to the question of prejudice to Mr. Cox, and then it continues on. So the discussion there is about prejudice or lack of prejudice considered by the trial court. That is that's the context in which this discussion is happening, not the standard for harm on appeal. So I don't know if that answers your honor's question.
I'm sorry. I wasn't sure if that answered the question.
Yes, and in fact, I think you're right. And I was allocating to Cox something that's said in Carper. And Carper does say there is this question about whether prejudice is a burden that a party seeking a reversal on appeal must carry in order to warrant reversal, or whether instead the kind of Kadiakis harmless error standard with a burden on the government applies. And are you saying that discussion in Carper was incorrect, and in fact it would be inconsistent with Neufeld or some other case to impose a prejudice requirement? As again, to be clear, a prejudice requirement as a burden that a party seeking a reversal on appeal must carry in order to show that an error in granting a continuance warrants reversal.
Yes, in two ways, Your Honor. That is, one is because in Carper, this court was conflating the court's discussion in Cox between the trial court's consideration of prejudice to the opposing party and harm on appeal. So Carper was misreading Cox. That's one way. But the second way, which even if the court doesn't want to go down that route, the language regarding that could be read to suggest that a party raising a claim of error based on a grant or denial of a continuance on appeal has to show prejudice itself is inconsistent with Newfield. So if we look at that, ultimately comes from trace back to Daly. I believe the sequence is Carper, Cox, Brooks, Mokhtar, Mack, Edelin, and then O'Connor. So it is the standard that is coming from, which these are cases cited in the district's brief before this court and in the reply brief. Hairston, Joyner, and Harris. Those cases are about not for a missing witness. Those cases are about continuances based on sort of broadly termed lawyer-related issues of newly retained counsel. So the notion that a party, in order to prevail on appeal from the either grant or denial of continuance, have to show prejudice itself is based on a divergent line of cases that isn't addressing missing witnesses.
Wait, but is your point that in Neufeld and the cases that are consistent with it, there are these elements that are required, and this isn't one of them, the prejudice, but isn't it in the mix or a relevant consideration, if not an element? And if that's true, how does that play into all this? I'm not sure. I might be getting confused about the whole Cox Carper thing, but You know what I mean? Or what is your ultimate point? If you didn't have to show that, and so therefore prejudice / harm is not relevant here now?
So harm
Okay.
is.
Yeah.
And under Katiakos, the burden shifts to the district if assuming there is error, which, you know, at the outset of the discussion, the court is assuming error, and the burden shifts to the district to show that the error, that it is highly probable that the error did not contribute to the verdict. And they haven't really even tried to make that showing.
Yeah. I guess I thought you were responding to Judge McLeese that Carper, you were explaining why Carper doesn't hurt, you know, basically isn't dispositive here, but Carper is talking about harm, or you're saying it's talking about prejudice.
So what I'm saying is
Okay.
when discussing harm in Carper, the court references its decision in Cox, which is not discussing harm, is discussing prejudice
Got it.
within
Got
the meaning of the trial court's discussion.
Now I understand. Thank you.
Can I ask you just to make sure I definitely get the line of thinking that you're suggesting, which I am summarizing as Carper is incorrect in its analysis of how to determine whether there was harm warranting a reversal. I get that line of thought. I think you'll acknowledge that if that's your only point, that's really a rehearing en banc kind of question rather than for us to decide. Do you have a point that's separate from that about why you think, even though if you take as correct Carper's treatment of harm and whether it warranted reversal, do you have an argument about why under the Carper analysis of that you could prevail? Or is, as it seems to me thus far, your only argument is Carper just has that issue incorrect?
No, I mean, I guess I would separate it into sort of two arguments. That is, one is that, as Your Honor said, it correctly summarized just now, and I'm not going to rehash that. The other is that in discussing harm, Carper refers to Mokhtar, I believe, which is ultimately traceable back to earlier controlling authority that does not include. Essentially, Mokhtar can be traced back to O'Connor in 1979, which O'Connor does not say that there is any, that in order to prevail on appeal, that any showing of prejudice is required. And so what
that still sounds to me like an argument that Carper is incorrect.
yes, it's a different way.
A related aspect of an argument that Carper's incorrect. But if Carper's reasoning is we're going to assume that the district bore the burden of showing harm, which is one thing we said we were doing in Carper. And then we said, you know, the harm issue, the harm that's been identified is a witness who otherwise wouldn't have testified did testify. And then we said, that's not the, I mean, if paraphrasing, we concluded that that's not the kind of harm that will warrant reversal under a harmless error standard where the burden was on the district. That seems like it's exactly applicable here. And so I just am not, I get your point that you think there are mistakes in that line of reasoning, but I'm just trying to figure out whether there's you have a second point, which is even if Carper is correct, you could still prevail. And I haven't quite gotten my head around that if you think there is that.
So slightly different argument, which also argues that Carper is incorrect, but in a way that I think this division could address.
You think we would have authority to say Carper is
because the earlier
because
decision
it's contrary to binding authority? And what's the bind? I understand your point that earlier Carper may have been incorrect in thinking that the authority it cited supported the conclusion it reached. I get that line of thinking, but that seems different from Carper contradicted some earlier binding authority on the question of how harm works in this exact setting. That's where I'm not quite, I don't have my head fully around your line of thinking yet.
Sure. So O'Connor says nothing, after laying out the 5 elements, it says nothing of that in order to prevail on appeal that a showing of prejudice is required. Whether we're going to analyze this under Katiakos, whether we are analyzing it in a different way.
Yeah, I get that. But I mean, I understand that line of thinking, but that isn't, are you saying that the silence of that in O'Connor is binding authority that precluded Carper from reaching the conclusion it reached? Because silence as binding authority is a tricky topic, I would think.
That is a not unfair way of saying that what I am saying, Your Honor. Yes. And I also just want to note that even, again, I know, this may be an argument beyond the division, but even if a showing of prejudice was required, the court's reliance in both Cox and then Carper on the sort of 403 type of unfair prejudice, which again, even the other factors we're talking about here don't say unfair prejudice, they just say simply any prejudice. And so it is again, may not be an argument for the division, but the 403 type unfair prejudice is just different in kind than prejudice that under 403, right? We have unfair prejudice on some improper basis, right? And even under the factor test, what we are talking about here is prejudice, not unfair prejudice, which appears nowhere
Mr.
in the
Madsen,
articulation of the standard.
I think I'd like to move you to the statutory issue.
Yes, Your Honor.
Briefly, because you're way over your time.
Yes, Your Honor, and I appreciate that. Thank you. So turning to the statutory issue, so prior to 2011, as the court is aware, the 22-13-12 read, it shall not be lawful for any person or persons to make any obscene or indecent exposure of his or her person, or to make, and then there's language that's
So
not
the
relevant.
council amended the statute at that point to include the in public language.
It did.
And if I understand your argument correctly, you're saying that in public language, you're saying a couple things. One, it's superfluous to the indecency, the way our cases have interpreted indecency under the law, and therefore should be essentially read differently. I guess you're saying in public must mean on public property.
Yes, Your Honor.
And I guess I want to hear your thoughts on I guess two different reasons. One, that it's superfluous language to what we already understood indecency to be. And on that topic, I guess I want to hear more from you about how the in public language would be superfluous to how we define indecency under our case law. Because I guess I see indecency going to the state of mind of the perpetrator of the alleged indecent conduct, and in public to be who sees or who has an opportunity to observe. So I don't see how those two pieces could be superfluous.
Sure, Your Honor. So looking at Parnagoni, or which quotes Payton, I would submit that the indecency does refer locationally. That is, indecent, an exposure becomes indecent when the defendant exposes himself at such a time and place where, as a reasonable man, he knew or should have known his act would be open to the observation of others. So I do think that indecent, prior to the amendments, the way that this court was interpreting indecent was locational, right? That is, it wasn't a distinction.
It was intentional. I think it went also largely to intent, whether the perpetrator of the conduct knew that the conduct, or should have known that the conduct could be observed by others. So I think that intentional component is definitely there. And if we want to, perhaps it also included a locational element, but I think the focus of it was what is the intent, what is known or should be known by the person perpetrating the conduct. And the in public language that the council inserted focuses on who's able to see it, whether the public at large, people in the public can see it.
Respectfully, Your Honor, I think that is a misreading. That is, I think that the indecency refers to exactly what that Your Honor referred to in terms of the council adding in public. That is in Parnagoni, taking Parnagoni as an example, right? We had this this is in a basement playing this deranged game of ping pong, and so the question there was primarily locational, and the court said, well, this is indecent because the Parnagoni knew, and
because he knew or should have known. It's
clearly known that it would have been open.
I'm sorry to talk over you.
I'm sorry.
But I guess the point I'm making is it goes to the defendant or appellant's subjective, what he knew or should have known, intent about what could be seen and observed.
So, Your Honor, I think that's inconsistent with the way, at least prior to the amendments, that this court has that interpreted it, the intent required for the statute. That is, prior to the 2011 amendments, this court has sort of expressly said, the intent doesn't need to be to expose yourself to a particular person. Sort of, there's this discussion. I don't recall whether it's in Parnagoni or
In
Will and
Payton,
Love.
I think you're talking about the language in Payton, whether they knew or should have known their act is open to the observation of others.
Not just that, Your Honor. There's a sort of a separate later case, and again, I don't recall whether it's Will and Love, which is cited in the briefing, or Parnagoni, but in
Parnagoni, it says the defendant exposes himself at such a time and place where, as a reasonable man, he knows or should have known the act will be open to the observation of others.
Yes, I acknowledge that, Your Honor. What I'm saying is there was a question, and again, I can't recall which case it was, but about whether in order for evidence to be sufficient to support a conviction under that version of the statute, that that a person had to intend to expose themselves to any particular person. And the answer that this court said was no, essentially describing this. I know this court eschews the use of this phrase now, but essentially describing it as a general intent offense. And
What do you make of your of the government's argument, and it's obviously true, there are redundancies in a lot of statutes, and here, even if you're right about these two phrases doing kind of being very close in meaning, they still are playing different roles, like without in public. If you don't have it in public in there, you're relying on indecent, that term is doing a lot of work that in public, helps clarify, I think, and the other way, without indecent, the statute might run into constitutional First Amendment issues, It's like, you could sort of see if indecent is the only thing you have there, it's not kind of telling the reader what we really mean here.
I agree that there is an issue that the indecent doesn't may not provide actual notice in terms of what it means, but in terms of what this court had interpreted it to mean prior to the amendments. That is, in view of the people at large, the several different phrasings. And so, if in public has to have some other meaning other than that, I mean,
presumably when the council is amending something, they're not thinking of a public that maybe they are that has read all the footnotes of our cases. They're thinking of something that communicates with clarity to people.
Sure. I guess when the council in this particular case, when the council was amending the statute, they sort of were addressing issues of vagueness and not vagueness in the constitutional sense, but and enforcement, right? And so drawing, I think the language is something like wanting to draw a bright line, right? And so if
they wanted to draw a bright line, they could have said in or on public property, but they didn't say that. They said in public, which I think under statutory interpretation canons have to look to see whether we can give some meaning to that language before we write it out as superfluous. And it would have been seemingly pretty easy for the council if their intention was to say public buildings only. And if we did that, or if the language did say that, that would seem to lead to some pretty concerning results. Would that mean, as some of the briefing by opponents says, that a person could stand in the middle of a shopping mall or go to a private daycare center and expose themselves, and because that's not in or on public property, then it wouldn't be in public?
I guess that, I'd sort of limit the question to the statutory interpretation here, but.
Well, I like the broadness of the question.
But I guess one thing I'll say, Your Honor, is, in Parnagoni, when this court reference specifically an earlier version of the statute. So we're talking even earlier now, when the pre-2011 version of the statute was under discussion. The either the council or Congress, I don't recall the legislature at the moment, but deleting the phrase "in public" as a reason to say that the statute applied in "quote unquote" private settings, which this court had already interpreted to mean, in view of the public. And then the council did the very thing that this court had referred to in relying on to say that this applies, where somebody is in view of other people. I'm paraphrasing, but the council did the very thing that this court relied on the absence of, the deletion of in prior history. And so it suggests that the council had a different meaning than what was already in place.
Well, let's say that's true. Let's assume for a moment that "in public" has to be construed to add something to what would have been the scope of the statute. It needs to add a limit beyond the scope of the statute before that language was added. It's a sort of a largely unstated premise of your argument that "in public" means publicly owned. That means like governmentally owned. But "in public" isn't always used that way. Your opponent cites some statutory settings where "in public" is used to mean something different. And things like public accommodations are not necessarily publicly owned. And so why do you think that we should construe "in public" to mean governmentally owned, assuming that it adds something?
I think absent sort of more, given what indecent already meant, and absent more specific guidance from the legislature in writing the statute, that is the most natural reading in terms of what it can't mean to add something.
Why is that? It seems to me another possible, like public accommodations. So if you wanted to say, is an area public or not public, you might mean, is it owned by the government or is it not? But if somebody said, is someone who is walking around in a shopping mall out in public or in private, I think ordinary language would lead you to think, well, the person is out in public. I mean, it's privately owned property, let's say, but so it just isn't immediately apparent to me that as a matter of ordinary language or anything else, you would interpolate into the phrase "in public," which is not clear about, I think, which of a number of possible interpretations of "in public" would be meant. At least on its face, it's not so clear. Why you would immediately leap to publicly owned isn't immediately apparent to me. So what am I missing?
So I think one reason is, in the legislature's amendment of the statute, they wanted to draw bright lines. One way to draw bright lines is, we've got property lines, right? We have ways of dividing this, so that there is no sort of, I mean, maybe a question in the moment, but not ultimately in terms of enforcement, right? What we have, under the argument offered by the district, we have sort of this very, kind of, I know it when I see it, sort of test.
I mean, I get your idea that it might be a comparative advantage to some of the possible alternatives to governmentally owned as meanings of "in public," that, property ownership is relatively easy to understand. But there are, countervailing considerations, an aspect of the chief's earlier question. There are doctrines against absurdity and the like. And so do you think it is, how plausible do you think it is to think that by adding that language, the district, the DC Council intended to make it legal to, in the middle of a shopping mall or in any privately owned place? And by the way, some places where government activities are conducted are not governmentally owned, like GSA leases buildings from private owners. And so you could go into a government office and expose yourself without violating the statute on the interpretation you're pressing. And your opponent makes an argument essentially that that's just an absurd reading, and whatever the marginal clarity you get from it, it just runs afoul of other fundamental canons of statutory interpretation. So what's your response to that concern?
Sure. So I think to the broader concern, I think certainly there are other statutes that may address much of, the hypothetical conduct that both Chief Judge Blackmun-Riggs's question and Your Honor's question, Judge McLeese, addressed, things like unlawful entry, right? There may be other statutes that address it. We're not addressing, I'm
interested in that line of thinking. Unlawful entry, I think if isn't immediately apparent as a preventative for those hypotheticals. It might affect the duration of them if someone lawfully in authority said, don't do that here, leave. But it doesn't seem like it would be a preventative. So do you have other, I mean, you said there might be other statutes that would address that absurdity concern, but do you have specific ones in mind other than unlawful entry?
Sure. I mean, so I confess this wasn't my exact line of thought before the argument, but I mean, I think in the there might be things like, you know, depending on the specific conduct involved, there could be intent to frighten, assault, some sort of, you know, depending on again, I acknowledge it would require additional conduct beyond just, assumedly beyond just being present and being exposed. I think it's fair to say that.
You've said I think you've acknowledged that at least in some settings, to refer to an area as public can reasonably be understood to mean something other than owned by the government. Is that fair? Do you agree that's true sometimes?
Sometimes, yes.
That means that. You've said that there's an advantage to construing it as owned by the government in that that's a clearer rule than other possibilities, like, for example, accessible to the public and open to the public, as that's used in things like public accommodation law or the like. There's a possible countervailing consideration of absurdity or the like. Another countervailing consideration that your opponent relies upon is the language of the legislative history, where the phrase that is used by the council in the committee report is not about government ownership of the property, but instead about kind of openness to the public. Do you agree that to a degree weighs against the position you're taking, or how do you respond to that?
No, I think it weighs the opposite way, right? That is, you know, because the council was aware of the way that this court had interpreted indecent previously, chose to continue to have the word indecent remain in the statute and add the phrase.
I get that argument about superfluity. That's another possible factor on your side, depending again on what you think the statute otherwise would have meant. But just the language in the committee report itself doesn't seem to, at least in ways I've seen understood yet, cut in your favor. It seems to a degree weigh against you. I understand you want to put it in the reasonably want to put it in the context of what they actually enacted. I get that, but just in terms of the sentence in the legislative history itself, it seems to suggest an understanding of in public that's inconsistent with the view you're espousing.
I would agree that one could read that way. Yes, sir.
All right, Mr. Mess,
Yes.
I will still reserve some time for rebuttal.
Thank you.
Okay. Is the district ready to proceed?
Thank you, Your Honors, and may it please the court, Tessa Jellerson for the District of Columbia. I'd like to start with the issue of the question of whether or not the trial court abused its discretion in granting a continuance. As was made clear from the discussion we heard earlier, Mr. Flowers' main premise here is that this court's most recent decisions in both Carper and Cox were wrongly decided. And that's the only avenue he has for a successful challenge here. We would, however, contend that both Carper and Cox are squarely binding and create a clear path for a resolution of this case. Much like this court said in both Carper and Cox, this case can be resolved on the narrow ground that even if there is a mandatory 5-factor test, and even if we assume there was some error in the application of that test by the trial court, there certainly is no prejudice. But I would also, taking a step back, Your Honors, dispute the contention first that there is a mandatory 5-factor test, and also that there was any error in the showing made by the district or in the trial court's application. And I'd like to start with the showing, Your Honors, if I may. So first, the trial court made clear that it considered both the district's motion for a continuance and also Mr. Flowers' opposition in assessing whether or not to grant the continuance.
You mean it made clear just by saying on consideration of X and Y, then it just found granted, right? It's like about as bare bones as you could have.
Correct, Your Honor. But I would say that's not a departure from what we saw in Cox or Carper, where an oral ruling was made from the bench that there was good cause for a continuance, and this court found there was a sufficient record to allow for appellate review of the issue. And I'd like to walk Your Honor through the showing that the district did make in their motion for each of the factors. So first, the district said as to who the witness was, it identified Ms. Akpala by name and said that she was the victim in the case. In terms of the content of her testimony, again, it had said that she was the victim, that she was an eyewitness, and that she was prepared to testify in detail as to her observations on the incident date. As to the relevance and the competence of her testimony, the court was aware from both the district's motion and from Mr. Flowers' opposition that there had already been a first trial here where Ms. Akpala testified. And though Mr. Flowers lodged immediate objection to the district's motion requesting a continuance, he didn't flag any issues with the competency of Ms. Akpala's testimony. And again, the relevance of her testimony as the victim and an eyewitness was clear.
But that's the thing, we don't, this was not the judge who tried the case, the first case, right? And so it is true that there, you know, if that judge wanted to find out what that witness had said at the first trial, he could have. Do we have any evidence that he did? It's, yeah, this might be going against what you say Cox and Carper say. I should know, especially about Carper, about, you know, about their, apparently we can have enough for appellate review by looking at what the government's arguments were. But, you know, at some point, we want to know what the judge thought of the government's arguments. I guess your point is just that we can glean what he thought about them because he granted the continuance, but how do we review that?
Sure. Well, I think it's certainly in this case, it's not a close question. And I think we have many cases like the MMNG case where even though this court said that it was not entirely clear what the basis for the trial court's decision was, there was still sufficient factual record for appellate review. And I would also say that in terms of, Your Honor is right, that the judge who granted the continuance wasn't the judge overseeing the first trial. That being said, there is case law, for example, the Daly case, where all that was said was that the witness whose testimony was needed was a former coworker and an eyewitness to the shooting. And there, this court said that was enough for the reviewing trial court to understand the relevance and the competence of the testimony. And here we had something quite comparable. We had that she was the victim and an essential witness. And moving to the next factor, Your Honor, is whether or not the witness could be obtained if a continuance was granted. And here, this is not the prototypical missing witness case per se. Ms. Akpala's location was known. She had already voluntarily testified in the first trial, and our motion made clear that she was in constant communication with the district and that she was committed to serving as a witness.
Is it in the record whether she was subpoenaed?
It's not in the record, Your Honor. And at that point, she had not been subpoenaed because she was so invested in testifying. The reason that we were asking for a continuance is because though this potential conflict had come up with work, we wanted to make sure that she could appear.
Is there evidence in the record about the extent to which there had been diligence in the sense of that problem was brought to the court's attention promptly as soon as it was learned by the government in a way that didn't result in undue delays or the like? What did the record show on that component of diligence?
Yes, Your Honor. Two things on that point. First, our motion made clear that the same day that Ms. Akpala learned she had this work conference, she immediately that same day communicated the issue to the government. And we, within a handful of days, I think 3 or 4 days, if I'm not mistaken, filed our motion for continuance. So there was certainly no undue delay. And we also made clear that we would be prepared to make ourselves available at the court's next earliest availability. So I think that speaks to due diligence there, Your Honors.
So if we were to disagree and say that particularly on the due diligence piece, there was not a sufficient showing or that the government could have done more on its due diligence, then we would get to an assessment of harm. And do you agree, I guess, with appellant's counsel's argument that Carper may not have fully resolved the whole question of whether prejudice should be considered as a part of the harmlessness in general, when you're looking at abuse of discretion, or whether or not prejudice is something that needs to be looked at more specifically in the context of these kinds of missing witness cases. Was that resolved sufficiently in Carper? And if not, do we need to make that clear
I
in
think
our
it was,
decision in this case?
forgive me, I think it was resolved in order to allow a resolution for this case. And let me explain what I mean by that. In Carper, we made quite clear that there is a long line of precedent going back to Mokhtar, back to Mack, that says that if the appellant challenging the grant of a continuance does not make a showing of prejudice, there can be no abuse of discretion. So this court could simply cite that line of case, cite Mokhtar, cite Carper, and that would resolve the issue, because this court has made clear repeatedly that the mere admission of adverse testimony, which is the only prejudice that Mr. Flowers has pointed to on appeal, cannot qualify as prejudice.
Have we, I guess, I'm not aware of any cases that are cited by either party where we have found that the prejudice was so significant that the continuance was an abuse of discretion. Did the district cite any cases where prejudice was found and therefore the continuance was found to be an abuse of discretion?
Yes, Your Honor. There certainly are cases where that was the case. So for example, one is the Daly case. And those instances where prejudice has been found are quite far afield. So some examples I can give you are where, for example, a party was unable to attend, and this court on appellate review finds that the testimony that would have been presented was so crucial to the resolution of the case, or counsel shows up and asks for a continuance because they're simply not prepared to proceed. And so this court found.
No, I'm talking about the government. Anything more analogous here where the government is seeking the continuance, or and the court found that granting the continuance prejudiced?
Oh, forgive me, Your Honor. There is no case within this district where the grant of a continuance has been found to be an abuse of discretion. Forgive me, I misheard the question.
Can I ask you, the mode of reasoning you were suggesting just a minute ago was to say reversal on appeal is required for an erroneous grant or an inadequately supported grant of a continuance only if there's an abuse of discretion. A component of abuse of discretion is prejudice, and presence of a witness whose testimony is admissible isn't the form of prejudice that warrants reversal. That isn't the same mode of reasoning that was in Carper. That was, do you agree, or do you think that was the mode of reasoning in Carper? I thought that Carper had said that's one way of looking at it, but we're not necessarily have to adopt that because the district wasn't really framing its argument in those terms in that case. And instead we were going to apply a concept of harmlessness rather than a concept of prejudice, although they're obviously related in various ways. So it seems to me that the line of reasoning you were just suggesting a minute ago runs beyond how we analyzed it in Carper. Do you agree with that, or do you think that really is what we did in Carper?
Well, I think Your Honor is right in the following sense. So in Carper, this court did note that there is a line of precedent, Mokhtar being one emblematic example, under which this question of prejudice could be resolved. As you rightly note, Carper then went a step further and said the district isn't invoking that here. Instead, they've relied on the Kodiakos harmless error framework, and went on to say that even applying that framework, any error here was harmless. And I think if your court was to do the same thing here, we would say that the district has also implicitly briefed that issue. Kodiakos does not impose a burden of production of evidence, and it's an argumentative burden. And here the district did argue first that Mr. Flowers had not made a showing of prejudice, but also on page 12 of our brief, we make quite clear that he also was not prejudiced, full stop. And we go on to explain why that is so. So even if this court were to apply the Kodiakos framework, we would find that we had carried our burden there. And I also want to just take a step back and make clear that we see prejudice as being baked into the 5 factors to begin with. And let me explain what I mean by that. I think that the first three factors, which are who the witness is, what their testimony would be, and the relevance and competence of their testimony, all speak to a prospective assessment of what the risk of prejudice would be if to the party who's seeking a continuance, if it were denied. And the latter two factors, whether or not the witness could be obtained if a continuance was granted, and the due diligence, speak to the potential risk of prejudice to the party who's opposing the grant of a continuance. And I think it's quite clear, we heard from opposing counsel a suggestion that prejudice is not something that the trial court should be considering or that should be properly considered on appeal. But I think that runs directly in conflict with not only Mokhtar and Mack and other cases, but also Newfield itself, which considered whether, which said that Newfield had not established, and I quote, any harm came to him through the refusal of the continuance.
And so do you see it then as the defendant's burden at that point, even though the showing is generally the government's burden?
Yes, Your Honor. I would say on the line of cases of Mokhtar and Mack and Newfield, it would be Mr. Flowers' burden here to make a showing of prejudice. I would like to make one other point, Your Honors. I would like to just note the sizable and significant administrative burden that this court would be placing on the trial court's docket if it were to view this as a mandatory test that must be run through in every instance. As many of this court's cases make clear that in any given case, it may be the defendant or it may be the government who is seeking a continuance, and there will often be within a given case multiple requests for continuances. So trial courts would have to then figure out which framework, which series of factors are we talking about, because this court has articulated different factors when it's a missing witness or more time to consider a plea deal or a missing stenographer in one case, for example. And the trial court would have to be extraordinarily diligent in making sure that each factor was met, because parties would no longer be incentivized to cooperate and can find a consent to continuances with each
And
other.
If Newfeld says that, you may disagree, but if say we think Newfeld or some binding case from pre-map says that these are requirements, even if it's a bad idea, what is your argument for why we don't apply them?
Sure. Your Honor, I would say that Newfield does not say that these are mandatory showings that have to be made before the trial court. In our view, the best reading of Newfield is that these are factors that a party must show in order to establish an entitlement to a continuance, such that if the continuance is denied on appeal, they could successfully challenge that denial. But it's not the case that the only circumstances in which a trial court could grant a continuance and be acting within its proper scope of discretion is if each of these factors are met. And this is a perfect example of why that is so. Unlike the prototypical missing witness case, where in the middle of trial, a party decides that they want to then go track down a missing witness, or a witness simply doesn't show up. In those circumstances, it makes much more sense to ask about, did you subpoena them? What did you do to make sure they showed up? Were you really exercising due diligence? Those questions are not as probative here, where this is simply a scheduling conflict that arose 2 months before trial was set to begin. And as soon as the district realized that there was an issue, it immediately flagged the issue for opposing counsel and for the court. And I would also point your honors to some of this court's own case law, which have read Newfield in precisely that way.
Wait, I'm sorry, are you saying that as long as it's 2 months before trial, even if it is a good idea in the middle of trial, like where does that requirement come from? If you think in the middle of trial, a judge should analyze these factors, but not because, there are lots of disruptions or whatever, but not 2 months before. Are you just saying in a judge's discretion, they probably should do that, but they're not required to in the middle of trial?
Sure. Yes, I did not mean to suggest that as soon as trial kicks in, these factors become mandatory showings. I just meant to show that, meant to try to articulate that these factors are probative of a prospective assessment of prejudice. And I think which factors may be more probative may depend on the circumstances of what's going on.
Mm-hmm.
And I think that's part of the reason why we commit this decision in the first instance to the trial court, because they're the ones who are really interacting with the parties and are best positioned to assess whether a continuance is really reasonably necessary for a just determination of the cause, which is the key question here.
Yeah, I mean, you still could 2 months before have, diligence issues and things like that. And I mean, that's what's frustrating about this case is you just don't really have evidence that the trial judge grappled with any of these issues.
Well, not so, Your Honor. We would say that the district made clear that on the day that Ms. Akpala learned that she had this issue, she immediately flagged it for the district. And within days, we immediately not only communicated with Mr. Flowers' counsel, but also flagged the issue for the court. So I would think that that would be a sufficient showing of due diligence.
You may be about to do it yourself, but you were about to refer us to one or more cases that you were indicating had read Newfield as more about entitlements to continuances rather than a flat requirement of a showing in order to permit the trial court to exercise its discretion to grant one. So I just wanted to put you back on that horse if you
Yes.
weren't already going to jump there yourself.
Thank you, Your Honor. So I was going to point the court to Gilmore, which is a 1959 case. The site is 273 F2D 79. And there it cites to Newfield for the proposition that a party seeking review of a refusal of a continuance must make a specific showing. And it goes on to explain that the party must, because the question before the court is whether a continuance is reasonably necessary for a just determination of the case, the party must offer to prove what evidence, if any, will be gained from the grant of a continuance. And another case is Brown, which is a 1968 case, which again cites to Newfield for the same proposition for it being relevant when a party is seeking review of a refusal of a continuance. And I would also note this is how other jurisdictions have read Newfield. So the Supreme Court of Maine in State v. Briggs has said expressly that Newfield applies most directly to the review of a denial of a motion for a continuance. The absence of one or more of the factors does not make the grant of a continuance improper. And in our briefing, we also pointed to Georgia as an example of a jurisdiction that has statutorily codified these factors. But they only apply those factors strictly in reviewing the denial of a continuance. They relax the application when they're reviewing instead a grant of a continuance.
You in your brief, draw a big distinction between the grant and the denial, but isn't it, sort of saying that denying will undermine a just determination of the case if it precludes relevant testimony as compared to granting? But isn't it possible that granting, I mean, you just don't know what the circumstances are. Granting could make one of the non-movement witnesses go away or die or disappear if they're kind of hard to keep an eye on.
Sure, Your Honor, we're not disputing that in some circumstances, it may well be that prejudice does flow from the grant of a denial, but that is certainly not the facts of this case, where the only prejudice that has been identified is the admission of adverse testimony. And we'd also say that probably one of the explanations for why this court has never found that the grant of a continuance rises to the level of an abuse of discretion is because in most circumstances, a grant of a continuance that's modest doesn't harm anyone's rights. Instead, it's docket management as it was here, and it's a necessary part of the trial court's responsibilities.
All right. Did you want to address the statutory arguments?
Yes, Your Honor.
Can I start you off with a question, like a framework question about the statute? What do you think has to be in public? Do you think in public, which has some sort of a possibly locationally driven concept, is it referring to the body of the exposing person or to like the location of a potential audience? What has to be in public in your view? What physical object
Sure. I would think it's the individual who's exposing themselves has to be in public, which we understand to be an open view before the people at large.
I thought, I guess I clearly picked up from your brief a disagreement with the idea that it has to mean governmentally owned. I guess I was a little murkier about what you think it means other than that. At times there's reference to things that are kind of legally open to the public, sort of like a public accommodation, like a shopping mall is open to the public. It's private property typically, but it's open to the public. And that might have one scope for the statute if that's the only thing it means. Then there's one place where you use the general dictionary definition, which is something like able to be seen by many people.
Mhm.
Which again, if someone was, went into a shopping mall when it's closed at night and there's nobody around and exposed himself or herself, that would be in a place that's generally open to the public. You might have to figure out whether it has to be open to the public at the time of the exposure. But if instead the focus is on, was there a public around at the time? A deserted shopping mall might not be. And then, you know, if sometimes it's open to other people without many, and the dictionary definition is many. So I was a little unsure about exactly what you think it does mean, although it was clear that you don't think it means on publicly owned property. So among those possibilities, which of those would you settle on? Or
Sure. So I would say that the statutory intent requirement is a general one, so that it doesn't have to be a requirement to expose yourself to one individual, which is why I think in the hypothetical of the shopping mall, we wouldn't say the mere fact that nobody.
again, I'm sorry to interrupt, I guess,
Sure.
but I'd rather not get into what the intent requirement is and just trying to figure out when, you know, let's say all person X exposed his or her genitalia in a particular place at a particular time. And the issue was that in public? Leave aside whether it was intentional, it could have been accidental, who knows? I'm not really worried about intent. I'm just trying to figure out when are exposures of genitalia in public in the relevant sense. So
Sure.
leave aside accident or intent, or whether anybody is, you know, and it might be your answer is, the answer to that depends on whether people are around. I don't think, anyway, I'm trying to separate the intent piece of it from the in public piece of it, I guess is what my interruption is intended to
Sure.
convey.
Sure, let me take a second stab at answering that. So we would say that in the universe of both public and private property, our conception of.
And when, sorry to interrupt yet again, I apologize a second time. I find it confusing to just use the phrase public property because that seems to me ambiguous. Do you mean, when you are using public property, do you mean publicly owned property? Do you mean property that is accessible to the public? Do you mean property that is devoted to public functions? The word public as referring to property, it has lots of different possible meanings. So it
Sure.
would help, I
So-
guess, if you were specific about which one you meant.
Yes, Your Honor. So in the universe of publicly owned property and also privately owned property, we would say that there's overlap in both fields for what we would consider to be in public. So let me explain what I mean by that. Most publicly owned property is likely to be in open view before the people at large. So an area in which you are likely to be seen by non-consenting adults or minors. There is also,
So
however.
just hypotheticals, if someone is in the middle of some very isolated part of Rock Creek Park, and no one is around and no one has been around, you know, no one has been seen. It's the middle of winter and there's 6 inches of snow and someone exposes his or her genitalia. Is that in public?
Yes, Your Honor, we would view that as being in view of the public, in open view before the people at large, because
Meaning
there's
that it, and why is it in view of the public? You mean it because although in fact no one is around, there is no public there. In principle, there might have been, and that's all that is required, or what is it? What makes it in public other than it's on public property?
Correct, Your Honor, because it's a space to which the public has access to. And I think you're at risk that any number of non-consenting adults or minors could enter. And that's why I tried to tie in the intent requirement, Your Honor, as well, because you don't have to have a specific intent to expose yourself to any specific person, but instead a general intent which can be satisfied if you're simply.
And so another hypothetical, I guess, if you were on governmentally owned property, like let's say in Rock Creek Park, there are some public restrooms and someone exposes his or her genitalia. Again, it may or may not be indecent, may or may not have been intentional or accidental. So I'm trying to avoid those statutory additional components and focusing only on in public. That is a public restroom. It is open to the public and there might well be people there at any given time, though there might not be at the time of a particular exposure. Would you say that exposing your genitalia in that publicly owned property is in public or not in public? Again, it might not be indecent, it might not have been intentional. But,
Sure.
is it in public or not in public?
I think if you're within your own stall and the door is closed, then certainly not, which is why I say that there's not a perfect overlap between publicly owned property and in open view of the public, which also leads me to.
And that's because an individual stall in a public restroom is not generally accessible to the public in principle. Is that your line of thinking?
Correct, yes.
And so if you, on the other hand, in the common area of the public restroom, exposed to your genitalia, again, might be accidental, might not be obscene or indecent, you would take that as in public because that's generally open to the public, even if the public is not present at a given time. Is that?
Correct, yeah. If the hypothetical is that you're in Rock Creek Park and you're in the communal part of a restroom where anyone could walk in at any given time, you're not in a stall and you expose yourself, yes, we would say that's an open view of the public. And Your Honor's hypothetical raises another absurd consequence of adopting Mr. Flowers' definition here. His understanding of in public is that any public property is what is any act that is occurring on public property is where you're crossing the line. And that's significant not only for this part of section 221312, but also for the other two parts of this statute, which speak to masturbation and also specific sexual acts. Because
What about I'm sorry, but what about just, and I didn't mean to interrupt you,
Sure.
but like the public area of a bathroom, if there are urinals there?
No, and I think that illustrates perfectly the work that Indecent is still doing there, because we would say the normal exposure to use a urinal is not indecent. Just like we would say if this court had to apply the statute to a locker room and the general changing that happens in a locker room, it might be in public in the sense that it's an open view before the public at large, but we certainly wouldn't consider that to be an indecent exposure.
Okay, so it would meet Judge McLeese's question, but it would still not work.
And how about, like, if you're familiar with the facts of Parnagoni, if that's
Mhm.
pronouncing it correctly. So assuming that someone is in a private home and exposes his or her genitalia in the circumstances of Parnagoni,
Mhm.
would you think that is covered by the statute now or not covered by the statute?
In the circumstances of Parnagoni, where they're in a basement?
Yes.
I think that's quite a difficult question. And certainly we're not saying that adopting our definition would lead to no difficult questions. On the margins, there will be tricky cases. I think the trickiest is the hypothetical that you're raising. When you're in your own home, in what circumstances would your behavior cross the line? And it may very well be that Parnagoni would not be a violation under the post 2011 amendments of
And
the statute.
another hypothetical that is consistent, though maybe more aggravated in some respects than some of the old cases that involve people who are in motel rooms that they've rented or their own homes and are seen outside of the home. Because Parnagoni is also
Correct.
inside the home where the observation occurred. So if someone, and again, I'll add in facts here that will, I think, try to take away the concerns about other parts of the statute. So assume someone in an indecent way and on purpose stands at his or her window
Mhm.
that looks out over a public street where there's lots of traffic or whatever it is, and intentionally displays his or her genitalia. Would you say that's in public or not in public? It's not a place that's accessible to the public. And I think you said at one of my early questions that the body of the exposer has to be in public, whatever that means. So is that just categorically not in public because a private residence is not ordinarily accessible to the public? Or do you think that could be in public? And if so, how do you fit that with the definitions you've been?
Sure, Your Honor, that would be in public. The definition that we're propounding is in open view before the people at large. So in your hypothetical, if you're standing in front of a picture frame window and you know that, you're on the first floor, people walk by all the time, the blinds are not drawn, then yes, you would be in open view before the people at large, and that any number of people, any number of the people at large could observe you at any time.
But so it seems like if I'm catching, I mean, I see that line of thinking, that seems like a separate piece of what in public means. Part of what in public means, and it seemed like from some of your answers was, even if no one can see you at the time, if you are in a place that's generally accessible to the public, then you are in public. If your body is in a place and the exposure of your body is in a place where the public could generally be. That's one line of understanding what in public means. A separate line that I'm not sure it's easy to conceptually consolidate into one global approach is wherever your body is, if your body is in a place where even though your body is not generally accessible to the public, the depiction, the visual image you are creating with your body is out in a place that's accessible to the public. Is that the idea that your body has to be? It's, again, this is why I got back to where,
Sure.
what has to be where, your body or the visual image that you're projecting out from your body?
Sure. I think it's both. And I think the definition given in the legislative history makes that quite clear, where it says that it's not only where your body is physically located, but if the public at large can view the exposure that's occurring. The definition the council gave for in public is in open view before the people at large. And I would think that would squarely encompass a situation in which you're exposing yourself in front of a picture frame window, even if you are in the premise of your own home.
And just to ask one further hypothetical to make sure I understand your position about the general scope of the statute. To what extent, if any, do you think the statute would apply to someone who is in the privacy of his or her own home, but is videoing and live streaming out into the interweb display, an indecent display of genitalia? Is that in public because the vision, the digital information that is communicated from the camera out through the interweb is readily seen by the public, or how do you think that would work?
Sure. So I think if you're live streaming to particular customers who have subscribed to your service, that would not constitute as being in open view before the people at large. If you're sending your feed to projection in the middle of Times Square, for example, that would potentially be in open view before the people at large. So it would be a fact-bound analysis, Your Honor. I'd like to, if I may, just walk through, in our view, a few of the other reasons why the definition that the council used for in public and the definition that we're putting forward today is the definition that makes the most sense.
I was going to ask if you could also address opposing counsel's argument that the in public language that was added is superfluous to the indecency definition.
Sure, Your Honor. I would say, as your questions, the questions that you raised before opposing counsel made clear, I think that there is not perfect overlap between indecent and also in public. I think there's still room for indecent to speak to intent. As Your Honor made clear, we've understood it to be whether as a reasonable person, he knew or should have known that he was in view of others. As I mentioned, when I referenced the locker room hypothetical or the urinal hypothetical, I do think in those scenarios, indecency is also doing the work. And I think as our brief made clear, we don't, to the extent that there is some superfluousness, that's not necessarily an evil. I think it can be potentially a feature of the statutory scheme where the legislature wanted to make doubly clear that the meaning that had been distilled through judicial case law would be apparent to people who were reading the statute against whom it was being enforced, and also for people who had to enforce the statute on an everyday basis. And I would also say, to the extent there is superfluity for this provision of the statute, there certainly is none for the other two parts of the statute. So this statute speaks not only to indecent exposure, but also to masturbation and to specific sexual acts. And those two latter provisions are not qualified by obscene or indecent. They are only qualified by in public. So if we were to adopt Mr. Flowers' definition of in public, that would mean that since 2011, it was unlawful to masturbate or to engage in any specific sexual acts on public property, which includes publicly owned universities, it includes military bases, it includes government-run homeless shelters that serve families. And surely that cannot have been the intention of the council when it passed the 2011 amendments.
Thank you. Unless there are any other questions, I don't know if you had any further points that you wanted to make.
No, I think we've covered the main ones, which we believe that consistent with the plain text meaning of in public, the legislative history, and basic concerns about workability. I guess the last point I would make is that my opposing counsel suggested that the publicly owned versus privately owned property creates bright lines that are easily enforceable. We would push against that and suggest that it's a much more common sense analysis, whether you're in open view before the people at large, rather than who owns this particular parcel of land, which can readily switch hands at any given moment. And so for all those reasons, we would ask that this court affirm the trial court's decision here and affirm the conviction.
All right, thank you.
Thank you.
All right, Mr. Mattson, we'll give you 2 minutes for rebuttal.
Thank you. sort of in reverse order, the district suggested that Newfield could be read to be creating factors, not elements. I would just point the court to Kimes, which is cited in the briefing. As this is quoting Kimes. Although we agree that the minimal criteria were met in this case, satisfaction of the O'Connor criteria does not necessarily mandate a continuance. I don't really see any reasonable reading of Newfield, or even if leaving aside Newfield under O'Connor, this is a mandatory showing, not elements. I'll sort of rest in the briefing in terms of the factual arguments why I don't think the district has made that showing here. The district also referenced Mokhtar and the line of cases regarding whether a showing of prejudice is required in order to obtain reversal based on the denial of or grant of a motion for a continuance. Ultimately, those cases also trace back to O'Connor, which does not say anything of the sort. So I would those go back from Mokhtar to Mack to Edelin to O'Connor. So I would just encourage the court to go there. So that is essentially maybe a question of precedent on precedent, but certainly not what O'Connor says. The district also referenced the administrative burden it indicated would be put on courts from this. Frankly, I disagree with that proposition and think it is the opposite. That is, under the district's reading, there will be cases regularly continued and almost always a showing of harmless error which will not foster parties being ready or prepared for trial. You know, taking the example of this case, the district knew when the case was being set for trial. They apparently didn't have the witnesses availability on that date. And what do we have? We have another continuance that ended up being for about 2 months. I see that I'm out of time and I was already long over time. So unless there are any further questions, I would ask first that Mr. Flowers' conviction be vacated. If it is not vacated, that it be reversed at minimum for additional factual development.
All right, thank you. We'd like to thank both counsel for your briefs and arguments, and we'll take the matter under advisement. Thank you.